The U.S. Department of Justice is going after a recent law in Washington state that would force Catholic priests to violate the seal of confession. Why are there increasing numbers of states attempting to force the church and her priests to violate the sacrality of the sacrament of reconciliation? Joining us to discuss this and much more, Assistant Attorney General for Civil Rights at the U.S. Department of Justice, Harmeet Dhillon. Harmeet, so good to see you. Have you back on the show.
Raymond.
Delighted. As Assistant Attorney General for the Civil Rights Division at the Justice Department, you announced this lawsuit against the state of Washington this week, which would require priests, particularly priests, they're mentioned in the law, to violate any confession if they learn details about child abuse or neglect. The DOJ filed a lawsuit on June 23rd, and it argues that the Washington law violates the free exercise of religion for all Catholics. Explain the ramifications of this bill, and why did your office decide to take this up?
Well, thank you for asking. So first of all, starting with the president and then flowing down through the attorney general, religion is a top priority, and protecting people of faith. I mean, this country was founded on freedom of conscience, and so it is the first in the First Amendment as well. So, and I believe very deeply in that. And so, what we saw this law come across our tables, it's Washington State Bill 5375. It has a laudable goal of protecting children from child abuse, but it singles out priests as amongst other professionals who are allowed to raise privileges. So, for example, a lawyer can't be forced under this law to reveal things that are conveyed in the attorney-client privilege. Doctors cannot be forced to reveal information communicated under the patient-doctor privilege, but they did not allow priests to be able to invoke the same privilege in this circumstance, putting every Catholic priest at risk of excommunication if they follow a man's law. But you know, when you dig into it, it isn't just the priests who are being targeted by this law, because what we're hearing from priests in Washington State is parishioners. You know, you can imagine all kinds of backgrounds of people. They may have different issues legally in their background, which they're talking to their priest about and confessing that they're in violation of the law. And now they're afraid to go to confession because they don't know or believe that even the issue is going to be limited to the child abuse issue. And so people are violating their own faith to follow this law, and that will not stand in the United States. So we've taken on this law, and you know, we feel pretty good about it.
Yeah. Well, it targets priests specifically, Harmeet. I mean, they face 364 days in prison, a $5,000 fine. You call this anti-Catholic. Why are we seeing a number of other states? They already have this on the books in similar fashion. New Hampshire, North Carolina, Oklahoma, West Virginia, Texas, of all places. Why is breaking open a sacrament, a Catholic sacrament, the target of these legislators in states across the country?
Well, look, I mean, I think, again, the goal is laudable of protecting children, but this law is, I think, the only one of these that you just mentioned that singles out priests and treats priests differently, first of all. And second of all, the older laws that you mentioned, all these others, have been on the books for a long time, and no one's prosecuted priests for not for refusing to disclose this information.
So this is the first one that actually targets and distinguishes priests as someone that has to report or face these fines.
And so, you know, it's the death penalty for a priest's career, if you will, if they follow this law. And it puts every Catholic at risk of being adverse to the law. And so, you know, the government has many other ways of getting this information. And so the strictest scrutiny is applied to laws that burden religious exercise in our country, and this is one of those laws.
Why? I love that your department has taken up an array of cases, and I want to get into some of the other cases that perhaps have escaped coverage and they should be focused on. There's another case in Washington State, a vaccine case that you took up. Tell me about that and why your department decided to get involved here.
Well, this is a case where we filed an amicus brief last week in the Ninth Circuit, the notorious Ninth Circuit, where I practiced for so many years, and Coach Rolovich was fired from who's Catholic, was fired from Washington State University for refusing to take the COVID vaccine on religious grounds. And so his lawyers are now challenging this case up to the Ninth Circuit, and the United States has taken the position that it is a violation of the First Amendment for this public institution to have fired him for exercising his faith, and it's a case of First Amendment retaliation.
You all also just took up a Title IX case against California, where you see men, biological men, competing with girls and women in sports that are supposed to be women and girls exclusive sports. What are you all saying in that case? Why did that draw your eye?
Well, there's a couple of different things happening with California. There's always a target-rich environment, if you will, but California's UC system is on the opposite side of us for discrimination on a number of different grounds. We sent a letter to all of the K through 12 schools that are participants in the California Interscholastic Federation a couple of weeks ago, because you saw in the news boys taking a girls' trophy. And so we sent a letter saying, hey, this administration doesn't believe in this gender nonsense. It is two sexes, male and female, and Title IX was specifically passed to give girls and women opportunities. And that's being robbed today by this. California responded by suing me and my boss, Pam Bondi, and so we'll be seeing them in court to defend our position. But meanwhile, I think you're going to see much more action on this Title IX side in coming days and weeks.
I mean, Title IX is a federal law. I mean, it's on the books.
Title IX is a federal law, and California takes a lot of federal money, and every institution that's public in this country has to follow our laws. It's not optional for them.
I want to talk for a moment about the FACE Act. Now, that is an act that has been used for years, certainly during the Biden administration, to prosecute and jail pro-lifers at abortion clinics. Congressional Republicans are fighting to repeal the law entirely. You take a different view. You believe there's a dimension here, the FACE Act, that's been overlooked and that might actually protect pro-lifers and protesters. Why?
Well, so it explicitly does. And so first of all, the FACE Act on its face, if you will, protects both healthcare facilities and houses of worship. And the houses of worship part has not really been litigated much, but we're encouraging. Houses of worship are being firebombed, Catholic and Christian and synagogues around the United States. FACE Act is one way to prosecute those crimes. But secondly, there are crisis pregnancy centers all over the United States where people of faith usually minister to women in crisis about their pregnancies and encourage them to keep the baby and give them other alternatives. There have been over 200 attacks that have not been punished by the law against those facilities in recent years. And the DOJ prosecuted a couple, but the vast majority that the DOJ went after were not even people blocking access, but simply praying outside an abortion clinic and invoking God's name. And so we're not doing that anymore. That business is over in the DOJ. We're not going to punish First Amendment activity. That is just purely First Amendment activity. But we are encouraging folks to come forward if they run or have visited one of these institutions. And there have been a couple of incidents, like in Palm Springs, there was a firebombing of a fertility clinic. That's a FACE Act violation. And so, thank God no one was injured in that incident. It happened over a weekend. But, there's also other kinds of domestic terrorism charges that can be brought there. But so while the FACE Act is on the books, we will use it for good.
Yeah, I love that you are looking and focusing on these cases that directly affect so many Americans. And as you said, this First Amendment right has been ignored.
It has.
Certainly over the last 4 years and maybe going back a bit further. There's a Jerusalem coffee shop case, of all things, an ironic title when you hear the marrow of this case. Why did you get involved with that?
So we heard about a coffee house in Oakland, California, where on multiple instances, visibly Jewish patrons were denied service and shouted at and spat upon. And, to give some flavor of the attitude of the owners there, we cited some of the drinks and some of the decor there as well. There's an intifada beverage on the menu. There were the inverted red triangles that are, virtually like a swastika to Jews in the current debate. So they can have that. They can have swastikas all over their shop, but they have to serve all comers in the United States. And this is a law that dates back to the soda fountain era, where African Americans were denied service, and we said as American citizens, we're not going to stand for that. So the same goes for Jews in America, and any person of faith has a right to walk into an open establishment and be served. So we're suing them, and it's interesting that you can imagine the people who are caught up in this case have been caught up in some other things. So I think we have a lot to dig into there.
You're also defending voting rights. How is civil rights, your office, defending voting rights? I mean, I guess in this case, it has to do with illegal immigration. So we know a certain percentage of those illegal immigrants are voting in every election. And I guess this week, the DOJ filed a suit against Orange County because the California Register of Voters is accused, or the local office there rather, of hiding voter information from you all.
Right.
How is this allowed?
We have we basically enforce all of the federal civil rights statutes, and voting is one of those civil rights. So one of the statutes we administer is called Help America Vote Act. Help America Vote Act gives the federal government the right to, audit these papers that states are required to maintain. And every state, which is every state that runs a federal election, has to comply with our requirements. And so we asked Orange County, because we had seen a news report that there have been people who received ballots who are not citizens. Forget whether they're illegal or not. They can't vote if they're green card holders in our federal elections. And so we wanted the information to be able to verify that. We have a lot of databases that we can use to verify that. Well, Orange County gave us some of the information, but not all the information that's required by law. And so we had to sue them this week to get the information that we're entitled to so that we can make sure that all votes are counted and only citizens' votes are counted in Orange County. And so some of the pushback has been interesting, though it has been on this illegal immigration front. And the argument being made by people in California, where California is a so-called sanctuary state, is, well, what is the government going to do with that? I mean, I am just interested in on the voting front of making sure that only citizens are voting. And you now have some states. I heard an alarming report that Michigan has a law that is about to go into effect that actually will automatically register everybody. And then the burden is on the individual to take themselves off the voter rolls if they're not entitled to vote. That's ridiculous. It's a mockery of our federal election laws, and no other country runs their government like this. The country cannot run without some security for its laws and its borders. So we feel very strongly about this issue, and I've been doing election law, as you know, Raymond, for decades, and I was one of the president's lawyers, in fact, in the recent election cycle. So this is very important to make sure on a bipartisan basis or nonpartisan basis, all citizens should feel confidence in the outcome of the elections. And if you don't even know who's voting or whether they're citizens, you can't have that confidence.
In private practice, you defended and represented a lot of pro-life people, religious groups, as well as people who were suffering during those COVID restrictions. And I know you represented so many of those people during the COVID shutdowns. How did all of that shape your perspective on the work you're now doing in the civil rights
That's a great question. Throughout my entire career, I have been engaged in pro bono and then, sort of virtually full-time during COVID, cases involving religious liberty, all different kinds of religious issues, but the principle is faith is very important. And what's interesting is, dating back to I think an opinion written by Justice Scalia, of all people, faith had been kind of demoted to a second-class right in the bundle of rights in the First Amendment for decades. And a case that my nonprofit brought, the Center for American Liberty, called Tandon versus Newsom, has now been cited by hundreds or thousands of courts. It has elevated that right back up to where it is supposed to be. And the court said in that case, the Supreme Court said that it was illegal for California to ban people for coming together for Bible study in Northern California during COVID. We had a bunch of other claims as well. Those did not succeed, but the faith claim succeeded at the highest level. And so now people are using that ruling to bring all kinds of cases involving faith and putting the importance of faith right back where it should be, at the top of our bundle of rights.
Harmeet Dhillon, I'm glad you're on the case.
My pleasure.
Great to see you.
Thanks
Thank
for
you
having
for
me,
coming
Raymond.
in.